so much for the invitation to take part in this event. We are very glad to be with you today to tell you about our conversation, because at the current stage it is a conversation, although we were able to publish a preliminary article on what we have changed in the last months and years. Why do we dialogue? Not only because we are colleagues at this department, but also because we are both involved in a master in international trade law, which is run jointly by the University of Torino and the ATC ILO. You met Giuseppe Casale this morning, he's our activity manager. And within this context, of course, we have to address the issue of sustainability and trade, global value chains, trade law. In this master, we address global trade, the legal aspects of global trade by both a public international law perspective and a contract law perspective, especially contract law, but there is also this public law dimension. So we usually work like that. We try to explain the basics of our scholarships on a specific subject to each other first, and then we try to see how these fields of law may interact, if and whether they interplay. So our issue today, the one that we developed in our paper that was among the materials, is how do public international law and contract law interplay as far as sustainability is concerned. Yeah. So and what are the challenges? Is this interplay between public international law and contract law currently in place, or what are the challenges? Is it useful? Is it needed? So when I addressed my colleague, I first of all consider that international law about SDGs consists of shared principles, the SDGs themselves, that are included in a UN resolution, which has not binding and legal value, but it's a resolution by the UN. Oh, sorry, that's okay. Code of conduct that you are all aware of, and there are emerging international legal obligations, but we have to be very cautious about this, especially if we think of private actors. And my colleague Cristina explains to me that, of course, also in private law, law is about codes of conduct, so soft law, if we want to consider them like that, and the sustainability contractual clauses. So how international public law and contract law interplay, or may interplay, or should interplay in advancing SDGs? If I briefly share with you some basic considerations of public international law, and then ask you for raising your doubts, concerns, questions, ideas, suggestions. I would say that in public international, we have two subjects of the international law that are states and international organizations. And states do produce sources of international law, in particular treaties, which incorporate social environmental interests either directly or indirectly through the principle of systemic integration. So we interpret trade agreements in light of the broader context of international rules binding the parties to trade agreement, and try to incorporate interests linked to the environment or to human rights into the interpretation of trade agreements. But we also have, of course, domestic law incorporating treaty commitments. And if we think of the trade environment, the trade context, some of these domestic laws have extraterritorial effects. Think of the fact that an exporter incorporates some requirements that are foreseen by law of the country of destination, of the products it produces and exports. And international organizations, there's a lot of soft law that is produced by international organizations within or thanks to international organizations like principles, guidelines, code of conduct. And these principles, guidelines, and code of conduct do address private actors, while treaties normally do not have private actors as their formal addressees. They usually address legal obligations to the parties to the treaty, which are states or international organizations themselves. And of course, we have also seen the development of a very interesting mechanism within the ILO, for example, and references are in the footnotes of our papers if you are interested in, of enforcement of inter-private agreements through extrajudicial means within international organizations. So I've already mentioned private actors and multinational enterprises, but what is the legal status of private actors from a public international legal perspective? Well, as I already mentioned, they are not formal addressees of treaty obligations. And of course, they are indirectly addressed by treaty obligations, and especially through incorporation of treaty commitments into domestic law. What is the current role? They have certainly a very important role because, first of all, they may choose to adhere to internationally established codes of conduct, such as the UN Global Compact and other conducts you're all familiar with. So this is the current status and role. There are some initiatives taking place at the international level, and I'm referring to the open-ended intergovernmental working group on transnational corporations and human rights that is working in Geneva, and you have references to this in the materials, that are establishing, they are discussing a legally binding instrument. So in international law, what is it? Treaty, probably. We don't have many other options, are the customary law, treaty law, or acts of international organizations. If international organizations are entrusted with the power to adopt binding acts. And this is an attempt, but if we read the text, they are foreseeing that multinational enterprises are addressed via domestic law, so indirectly by international law, not directly. So the issue of the international legal subjectivity of multinational enterprises being then formal addressees of international legal obligations is still there. It is not resolved. It is not solved in that direction. And so how and when we can consider multinational enterprises as bearers of international legal obligations and liability as far as corporate social responsibility interests are concerned. They are legal persons unless we envisage an international crime. And we consider that moral persons are addressees of an international prohibition of committing an international crime, we have no way of considering multinational enterprises as subjects of international law. So there is this gap. And now we move to consider how private law, private contract, let's say, approaches this issue. And we see if there are as many gaps as in public international law, or if there are some advancement.
Now better, especially from home. So basically, thank you, Lorenza. Thank you very much indeed for having started our presentation today. Yes, I'm the private lawyer within our research team. I'm a comparative private lawyer from the University of Turin. And we share this engagement in a master program that is also a research program. And we share this interest for dialogue in between our disciplines. We were curious to understand how public international law and comparative private law, and specifically contracts, interplay in trying to achieve the SDGs. From the perspective of international organizations, they usually are very keen to invite. Could we say invite? We could not say delegate, because delegate is more risky. Multinationals and private actors to be engaged and to promote SDGs in their businesses, often global businesses. So the nature of this kind of invitation, delegation, involvement is quite an interesting relationship. For sure, we believe that this is our, I think, main point, is the fact that SDGs can be achieved by a cooperation of public and private actors. And from my perspective, the perspective of a private lawyer, this is a quite interesting point of view, because traditionally, I think you can agree with me about the fact that we tend to think that, private law, contract is the domain of freedom, in the sense that party autonomy is a well-established principle of contract law in civil law and common law as well. So we mean private actors, they can rule their transactions as they want. They have to respect the mandatory provisions, the overriding mandatory provisions of domestic laws. I mean, provisions about public interests, public policy, but, apart from that, they are free, basically. So this is also a reason why in private law, I think we have started a little bit later than our colleagues in public law to address this challenge of SDGs from our perspective of private lawyers. And indeed, only this September, so in this month, we had in the EU a huge conference organized by the Max Planck Institute in Hamburg about the private side of SDGs. A huge event where colleagues have considered each SDG in the perspective of private law. And I think this is a starting point, no? Indeed, if we look at the acquisition, we have obviously studies about CSR have been conducted by colleagues in corporate law and private law as well for a very, very long time. So indeed, the problem is to manage all the legal scholarship and to have an understanding of so many documents by organization and also so great contribution from scholars. So CSR is a well-developed area. But we have studied so far the role played by the codes of conduct. This is a well-established subject also in private law, in contract law, with excellent approaches and with an open question. How far declarations in codes of conduct are really legally binding, and who can enforce such declarations? Consumer associations, third parties. This is a well-established area. More recently, we, as private lawyers, have started to consider the role of clauses. So the possibility to include specific clauses in contracts, especially in the field of procurement. This is, I think, the best example, the most advanced area about what we used to call the contractualization of sustainability in contracts. Obviously, these sustainability contractual clauses have been initially explored from the perspective of public procurement and contracts together with, in between states and private actors and multinationals. So this is the most studied area, and we had great contributions about sustainability contractual clauses, also from the colleagues of Copenhagen that are part of this meeting as well. So the question that is still open to us is about the value of sustainability contractual clauses. And we can observe a positive development consisting in the fact that these clauses are becoming more and more common in commercial contracts. And starting from contracts where you have public institutions, now we see more often sustainability contractual clauses in business contracts between private actors, so between multinationals and suppliers. So from the public contracts to entirely private contracts. So it seems that there is this expansion of attention for these clauses also from the private side of multinationals. So from the codes of conduct, you have a clause into the contract. This is an example of this kind of sustainability clauses. There are different, they take different forms, they have different wordings, they have different legal meanings indeed. So this is the clause of Pirelli. Pirelli is a multinational from Italy with this attention for obviously code is operating globally. So basically they have a code of conduct, code of ethics, and so far. So basically they have the codes, and they used to include the clauses dealing with a number of SDGs in their contracts with suppliers. So you'll be able to see something like this, where the supplier from different jurisdictions undertakes to respect certain principles, values, commitments, including, there are many, covering all the economic, social, and environmental aspects of the SDGs. So there is this long list and this obligation. Respect, no? And there is also obviously some form of monitoring and some form of control, and for sure, some form of sanctioning from Pirelli, multinational before suppliers. So it is possible that someone from the supplier companies reporting in an anonymous way breaches of these obligations. There is the possibility of training by Pirelli employees. There is also this possibility of control and also audit by Pirelli itself, in other cases by third-party auditors. And what is amazing for me as a contra lawyer is to see that there is also an explicit mentioning to the rights of future generations, that in a contractual clause is indeed quite an interesting declaration. The point, and you'll agree with me, is when these clauses are creating valid legal obligations, meaning to an enforcement before the court. And this is the issue we are discussing in the EU and abroad. There are various positions. The common position of the majority of scholars today is it depends on the wording of the clause. If the clause is vague, extremely vague and unclear, and it contains only a declaration like, we would like to protect the future generations, full stop. It could be that the meaning, the terminology used is not legally binding, is a declaration Can we have declarations in contracts? Sure, obviously, this is well known, usually at the beginning, but not dealing with SDGs, usually dealing with the skills of the parties, the final goal of the transaction. So this is a new kind of declaration. The answer is depending on the warning. And the good question from our audience would be, could you comment on a decision by a court stating, yes, this is a legally binding clause, so if you breach the clause, you may be held liable. This is a very good question. And I have to say that to date, we do not have many cases and judgments, so it's difficult to build arguments on the case law because it's very, very limited in quantity and in quality. I have published on these aspects, and in my article, I have stressed the fact that the lack of case law is probably related to the way of sanctioning misbehavior, in the sense that usually Pirelli and multinationals more generally, they do not go to court to sanction the breach of the clause. They do differently. They put the supplier breaching the clause in a blacklist. They sanction by exclusion. So it's based on what we call relational remedies. So remedies based on informal approaches. And that usually these informal approaches are not visible in proceedings. So that's why, and we have many of possibility of sanctioning by relation. So the suppliers obviously are quite careful. They do not want to be out from the business, from this global business and to lose the multinational as a client. This de facto, this way of sanctioning informally may have quite a strong impact, but it is difficult to map. You need to do empirical studies, and to collect data and information from suppliers, and we will do, in the sense that there are preliminary empirical studies to try to map the various way we sanction. Some criticism and some perspectives. Obviously, in this uncertainty about the legally binding force of sustainability contractual clauses, we can assume that for multinationals, including these clauses is like an exercise of marketing and promoting the company before consumers and society as a whole. So it's a sort of declaration, but indeed is also a way to say, okay, we can legitimize the current way of mass production. So we are good, we care about SDGs, we put SDGs in as a goal in our codes, in our contracts, everywhere. So we are good. And the way we proceed is legitimate before the world, and is a good solution because you legitimate yourself. You do not have a clear legal accountability or liability for that in the current state of the legal framework and the case law in the EU and abroad. Indeed, is a good way to protect your reputation, to enhance your reputation. But anyway, it's also a way to limit your liability as a multinational, because the multinational may stress that the liability goes to the supplier itself. It is not based on the multinational that provided codes of conduct, clauses, and training, but it is up to the supplier. And so it's also a way to say, okay, we have a contract, that the supplier breached the contract. And so the supplier is the only liable legal subject that you have to claim with. Perspectives. This is an interesting exercise. For sure, we may expect that we will be able to develop at least in legal scholarship, a more detailed picture of liability for multinationals based on sustainability contractual clauses. So probably from Copenhagen, we don't know, we will have quite a good team working on this specifically and publishing on this aspect. So far, thanks to the creativity of legal scholars, we will be able to find arguments to clarify and to assess, to establish liability for such declarations. Indeed, if you think to the case of declarations of a multinational reaching consumers, so in case of goods and services that go to final consumers, basically we already have case law very clear stating that if this is misleading declaration, for example, we will care of sustainability, environmental sustainability, and we care, and then in de facto we have a situation where it is clear that it is not so. It is possible that this declaration is sanctioned and is a source of liability for damages because it's a sort of misleading advertising. So we can use different arguments based on different areas of contract law, like, you know, warranties. We are discussing of the warranties of the goods and services from the point of view of physical aspects, but also non-physical aspects. So if you have breached the SDGs to produce certain goods and services, it could be, and then it could be that this implies that they have less value, less economic value, because no one is willing to purchase goods and services that have been produced not respecting our values, our shared values. But anyway, it could be also that this could amount to a liability for lack of warranties and guarantees you should provide for goods and services. So we have different areas we are working on, from unfair commercial practices and warranties in the contract for the sale of goods that could be open for further elaboration, you know. And then there is also this interesting point that is about the impact of declarations from multinationals and contractualization in global value chains, in the sense that is a form of expression, is a form of developing consciousness from the multinational itself to the entire chain of suppliers. So there is this point that is based on Sunstein work, saying this is a way of signaling, let's say, you know, these values are important for our clients, for our company. And so if you would like to be a supplier and work with our group, you should respect these values. So it's a signal to the world, basically. So we hope that this way of signaling may have an impact on future developments in the behavior of suppliers. Obviously, we are in contract law. So basically, in contract law, it's different from the case that we have where you have company, the control, the corporate control on the company. I'm thinking to Vidanta case in the United Kingdom. And another point that we will address in the future is the distinction in the governance of the value chain. One thing, if you have a governance based on contract, or if you have a governance based on control. So basically you have the corporate control of the companies. And this obviously in the perspective of private and commercial law is very different. In contract law, we also face an additional and final problem. As you know, we have the privity of contract. That means that when the party can enforce the contract, but third parties can enforce the contract in a very limited way. They can claim before the court to enforce with many limitations because they are not part to the contract. And so as far as you enlarge the third parties you would like to involve and to see before the court, as far as you go, it is more and more difficult to argue in favor of a third party willing to enforce a sustainability clause in a contract. Let's assume is a community of people. Let's assume is a consumer association. Let's assume is an NGO. Is not a client, is not a supplier, but it is someone that ideally is willing to foster the benefit of future generations. This is in contract law technically is still an issue. Again, we are elaborating on this point, but the role of third parties in claiming for sustainability clauses is limited in our understanding of third parties to contract to date, but this is an open question if contract law is the most suitable area of private law to deal with these problems. Generally, we tend to discuss of the interplay between tort law. So how tort law and contract law can be different tools, and probably in certain cases, tort law that is very flexible to accommodate. So you do not have to have a contract and is probably more appropriate in certain circumstances. So another area in private law that plays an important role is maybe tort law. So basically, we now, I think we are running out of time, but this is our, our presentation for shared presentation and joint effort. We plan to work on this and to discuss more and more some preliminary conclusions. For example, probably we have to conceive the goal of achieving SDGs as an hybrid regulatory system, including private actors and public actors, and not limit our analysis to one side. We have to check the role of this kind of invitation by international organizations to private actors. Are they accountable by law or by contract? And we expect interesting developments also from the area of private law, because private law in the past, we were used to discuss of the social dimension of private law, especially in the European Union. And basically, I've written that probably the SDGs have to be conceived as the new social dimension of contract law. And finally, I was at the conference at UNCITRAL for the celebration of the work of UNCITRAL in Vienna, and we were discussing of sustainability contractual clauses, as Professor Caranta has just mentioned. And I was suggesting in that roundtable why you do not consider to insert a sustainability clause in your model laws that have a great impact globally. But I had the same concerned reaction, because they were thinking, this is trade law, this is not the place for sustainability, because we are not dealing with public contracts, but we are dealing with private actors as well. So thank you very much, and we can open for the discussion.
So thank you very much for both Lorenza and Cristina for this very interesting presentation. Of course, you see there are a lot of intersections between different topics. I will take a couple of questions before lunch. One is for Marta, please, and the other Valentina. No, not Valentina.
As you can see, I'm very excited. I made notes. It's always the first thing is I need to stand in the right way, not to stand to too many people with my back, so apologies. First and foremost, thank you so much for a wonderful presentation. It's so inspiring to hear recognition of importance of this also from this very commercial private law, but also understanding the public dimension. And I think that for us and for the ESRs, the particularly important element here to emphasize is that we can do a lot of great things within procurement, but ultimately the tool to carry, so to speak, the vehicle to carry those great goals within procurements, those are contracts. And if we don't address it in contracts, we have a bit of a problem. But my question to our very distinguished speakers is following. And as a pre-comment, I understand that probably an answer to it would be maybe that's not necessarily a legal issue, but societal, behavioral, etc. But where I see the main issue is that there is not really an interest of the parties involved in the contract to really move this discussion further. What I mean by that, yes, private companies, particularly if they are green or very progressive, they want those elements to be considered at the procurement stage if it gives them a competitive advantage so they can win the bids. But they are not very interested to have a very hardcore contractual clauses, so later on to be actually held responsible for it. And the same way, ultimately, on public side, from the procurer's perspective, we all know that no one wants to terminate the contract. No one is interested in that. So if we have both sides of this contractual agreement that ultimately that's where the standing point is, what can we do? And that will be my question, whether from both of your perspectives, you see that there is an option for actually legal solution, or this is something that we really need to ultimately address in behavioral sciences and other areas than law. Thank you so much.
I have a related question because you said that, of course, when you are dealing with private contracts, third parties cannot challenge whether the contract has been contract clauses have been properly enforced or not. But when it comes to public contracts, you might have some type of third parties that can do so, and those are the other participants in the award phase. They might have a saying, and especially, I mean, at national level now, we have some interesting cases concerning access to the executive phase, the performance of the contract. And if there is a breach on something that has been decided at the award stage, that was put in the tender notice and that was concluded, then a third party that, of course, has an interest that might not be so much connected to the to what we are interested in, but the result might be efficient. Thank you.
The floor is yours again.
Hey, good question. The behavioral solutions are, quite interesting for scholars. I wonder whether they are really effective in reaching the goals, in the sense that if you can go to a court, you can force. This is really different from hoping that if you signal something, your suppliers will care about. For sure, blacklisting, for example, is powerful, but indeed is also a question of our societies. If we take action, it means that we give priority to this value, and it could be that because of public interest, we can limit contractual freedom. It's a choice, no? In the sense that there are cases where private freedom is limited, and we can decide. For this reason, it's quite interesting to observe the recent proposals before certain in certain jurisdictions, like in Switzerland or things in the EU. But we go to the area of basically enforcing, so putting the states now and making the states working and passing laws like the Swiss proposal. But there is no obligation, as far as I understand, from the side of international law. So the state is not pushed to pass laws in this direction.
We have to, in international legal scholarship, we have to work on this concept of due diligence. So whether there is an international obligations upon states to exercise due diligence vis-a-vis the private actors under their jurisdictions and the relations that these private actors have with private actors under other jurisdictions. So this due diligence concept or legal obligation under international law may be the gateway. But I was inspired by Martin. I thank you for your questions. Is there I think that the issue for from an international legal perspective is there any legal obligation among international commitments binding states that oblige states to introduce this kind of strong clauses in their public contracts with private actors? So I guess that this is the research question and the direction of further research for that.
And coming to the second question, for sure, a third party can claim because of the breach of the contract. If the part, depending on jurisdictions, there is a difference in between common law and civil law. We have European Union shared understanding of the rights of third parties to contract. It's a long story, but anyway, the idea is basically to challenge you should show you have an interest in the contract, in the execution of the contract. The way the court gives the interpretation of the idea of interest is problematic because it's a narrow interpretation to date, but obviously the idea of public procurement and involvement of other participants, yes, they have an interest. I think this is not problematic. Obviously, the idea that is really fascinating is the role of NGOs or maybe communities, now in the sense of, I mean, ideal players, repeat shot players, to quote Galanter, in the sense very far from the parties that are trying to advance SDGs as associations. The very few cases we have in a comparative perspective are usually cases where the court has allowed the local communities in case of, for example, mineral exploitation. So we have some very limited examples where the local community has challenged the contract because, for example, of pollution, and the local community lives in the area and so suffer more than others. So the local community has a stronger interest. I can remember one case, I can give you the details, where it has been possible to open the door a little bit further. It was a case in my interest.
Sorry, Cristina. Just for the online audience, the question is, how is standing granted to local communities?
It depends on the factual background. I can give you the reference to the case I'm thinking about. You have a challenge because the local community stressed a unique interest because pollution is in the village and they live in that village. So we have a very strong interest. We suffer for this case of breach of environmental duties. And so they asked to the court to challenge a third party because of they live so close, basically.
I don't think this was in Italy.
No. I give you the reference.
No,
I have
no, just to conclude, just building on what I was saying yesterday, just keep in mind that law is different in different places, and the, let's say, European legal tradition is grounded on individuals. There were two seminal books by Solari in the early 20th century, and one was Individualismo e diritto privato, how private law, European continental private law, was grounded on the individual. But you have places, especially in Latin America, but also in Africa, where the legal subject is not the individual, is some form of community, the same as it was here before the French Revolution. And this guy, oh no, now it's called the Bobbio, but before it was called Solari, sorry. Thanks a lot for that, of course, a lot of food for thought. And I'm happy to see that our PhDs are starting to appreciate how tough it is to be an academic. 3 years more.